This is the current federal tax developments for the week of December 30th, 2024. Current federal tax developments are brought to you by Kaplan Financial Education and by your state society of CPAs. This week, we're going to look at a few developments that have taken place, including starting with a ruling from the Ninth Circuit Court of Appeals that upheld a tax court decision regarding the all events test and how it applied to a tomato processing plant that ended up having to do some major, let's say, restorations at the end of each harvest season. We'll talk about whether or not they were allowed to go ahead and accrue those, even though they came at the end of the season, they didn't get performed till the beginning of the next season, or where they had to delay them and treat them as part of the cost for the following year. And we'll talk about that background. We also have the tax court again to this time had another case on limited partnerships and whether or not the 1402A13 definition of a limited partner as such means that you have to give that exemption from self-employment income to anyone who is a state law limited partner. And not surprisingly, the tax court again in this case decided no, you don't. We'll see how the rest of that goes, but it was another win for the IRS here. Not really unsurprising, considering that in Sorobon Capital we had a published decision that came to that conclusion. Wasn't really surprising. One big difference here, though, was this case actually got a ruling that the partners in this case were considered to be not limited partners under 1402A13 because we actually saw an application of a functional test. And then finally, it has been a roller coaster week for the beneficial ownership information reports. And we had a on-again, off-again filing requirement. We're now still in the, as I record this today, still in the off-again status, and I'm recording it on Saturday, December the 28th. So, hey, you never know. Things change constantly, so maybe it's going to change again. We'll talk about the status as of Saturday, December the 28th, talk about potentially what might happen in the future, and see where we're going on the beneficial ownership information reports. But, you know, we got something at this point. We'll talk about where we're at and how we got here this week. So let's start with the Ninth Circuit ruling involving the tomato processors and their reconditioning expenses. And this is a case of the Morningstar Packing Company LP et al. Versus Commissioner. It was Tax Court Memorandum Decision 2021-42 earlier. The Ninth Circuit affirmed the case this week. Dockets number 21711191, 21711192, 21711193, and 21711194. The decisions were issued on December the 19th. Now, this case involved a tomato processing operation. Now, it runs at high volume during a 100-day harvest season each year, right? And this is a big supplier. They supply about 40% of the U.S. ingredient tomato paste and diced tomato market. So essentially, there's probably a real good chance you have consumed some of this entity's products, you know, via who they supplied to other suppliers down the line. You're not buying necessarily the tomato paste or diced tomatoes from them, but other companies whose products you have consumed have bought those. So big time supplier in this area. Now, during the harvest season, from July to October, the facility basically operates 24 hours a day, 7 days a week during that time frame running, right? And that entire facility is forced to cease production if any part fails due to a need to maintain their sterility, right? If any part fails, they've got to open up the system. That means having to re-sterilize everything again. So I got to go back and get things redone, get it, you know, maintain the sterile base. So clearly, a shutdown during this processing season is a problem. When you're 24/7, you don't really have time. You know, you're not able to like do things every day to keep things up and running. Rather, you're required to, as best you can, try to design a system that can run 24/7 for the 100 days. That's the goal, is to be able to hit that, and that imposes certain conditions on what you can do and when you can do it. That's also part of the deal. Now, their customers have high standards for quality, and they also have to pass a series of government inspections with the U.S. Department of Agriculture, the Food and Drug Administration, and with the state of California's agricultural people in order to stay in business. So they have all of those issues they look at when they're looking at this background. So again, we have high standards. got to keep the facility up, all of those issues in play. Now, the equipment undergoes extensive reconditioning at the beginning of each processing season, and the costs involved will range between $16.7 and $21 million. So the idea of this. Now, clearly, the company believes these are incurred based on the fact that they've run 100 days 24/7. So we get to the end of the processing season in October. They're saying essentially, look, all of this is dialed in. We also can estimate this relatively well as what it's going to cost. And the IRS isn't challenging that. However, we are challenging a bit on whether or not they could accrue it. Now, this comes down to if you're an accrual basis taxpayer for income tax purposes, what's known as the all events test. This all events test must be met in order to record an expense for tax purposes if you're using the overall accrual method of counting. And this is not a fight over how much of a deduction they get. The question is over when do they get it? Is this part of, and since we're sitting in between their processing seasons right now, would this being incurred right now be considered part of the 2024 processing season that ended in October and therefore would go into cost of sales for 2024 production? Or is it considered a cost of sale for the 2025 processing season? Because they're not going to actually perform this work until we get close to the start of the processing season in 25. So we're going to be waiting to get into this, big time reconditioning toward the beginning of the season, so that the plant at this instant should be sitting, assuming we're still doing things the same way, should be sitting in between, right? It's not yet been reconditioned. It's going to need to be reconditioned before they restart later in 2025. So that's where we're at. Now, to meet the all events test, there have to be a few things. First, you have to show the fact a liability exists. You are liable for something currently. Until the fact exists, you are not, you can't accrue something under all events. You also have to be able to show the amount of the liability must be determined with reasonable accuracy. Okay? And finally, economic performance must have occurred. In this particular situation, the only fight is over whether or not the fact of liability has been established. Are they truly liable? Do they have effectively no choice? And I mean absolutely no choice, but to go ahead and, perform this work. Is that required? Or is it really something yet that the fact of liability has not yet been established, right? It's something which, yes, we know they're almost certainly going to do it, but it's kind of like warranty costs, right? You know you're going to do it, but you still can't accrue them until you actually do them, right? There is no actual liability until somebody shows up with a broken piece of equipment. Then you have your liability is in place. That's your key. So the case turns on that question of whether a liability had been established. And remember, liability is established on the earlier of the event fixing the liability takes place or the date a payment is unconditionally due. Now, clearly, the date the payment is unconditionally due is not until they've actually done the work, right? They've actually taken on that work and done it. So the test here is, did the events fixing liability already take place? Which comes down to, did merely running the plant for 100 days fix an actual liability? Or is, in fact, there is no liability fix? They don't have to do anything, in theory, at this point in time. Nothing's yet been fixed. Again, this is looking more at legally, are they required to do it? Not whether or not they're going to do it. Everybody pretty much agrees we know they're going to do it. But can we yet accrue it? That's a different question. Okay. Now, the taxpayer argued two different theories about why the fact of liability was established at the end of harvesting season. The first factor they had was that their credit and loan agreements required that the plant maintain its equipment in good condition and repair. But it did have an exception for what says was ordinary wear and tear. The taxpayer's argument is, well, we have to do this work. That's the only way that this equipment is in good condition and repair, right? That's how it's going to be in that condition. If we didn't do it, we'd be in violation of our credit and loan agreements. And that would be a big problem. You don't violate your credit agreements. That creates problems like you lose your credit lines. You can't borrow anymore. To do that, that would be a bad idea. The second argument they have is that they have multi-year production contracts. So they have contracts that go, it's not just they have a contract for 2024, but they already have contracts that committed them to produce products in 2024 and 25. And you'll say 24, 25, 26. So they already have committed to having to produce products, for multiple years. So there's already a commitment that they're going to be running a 25 production run. They have to deliver product for 25. There's already a commitment to do that. And those contracts have extensive product quality specifications. And they're saying that requires us, therefore, because we're already committed to doing the 25 run, it's already committed us as soon as we have run the machine through the 24 run, we now have it in a position where we have got to recondition it. That is a requirement because we are committed. It's not as if, we have no contracts, we're not committed doing anything in 25. That's not what this is. This is simply, we have to do this to run in 25, and we're already committed that we have to do 25. We have contracts with companies that we have to provide them with the tomato products. So we have got to be able to get this going in 25. Having done the 24 run automatically means we have to pay these costs. That's the company's arguments in front of the court. Now, the tax court disagreed. They said these don't establish the fact of liability. And the Ninth Circuit majority agreed, saying that, in fact, that was what was there. It's very much there. We're not yet at this point. Now, the financing agreements, this one they said, well, these agreements all have exception for ordinary wear and tear. And the court looked and got a definition that wear and tear is deterioration caused by the ordinary use. And, and they said, well, running this equipment, it's what it's designed for. So running it during the processing cycle is ordinary wear and tear. Therefore, that is not something covered by the agreement. The agreement specifically excludes ordinary wear and tear from your requirement to keep this stuff in, good working order, right? And the court said, look, if the taxpayers' interpretations are correct, then they were out of compliance with their loan agreements most of the year. Because they're waiting to recondition equipment just before starting the next production cycle. So the court's argument is, as of right now, under their theory, as of right now, sitting here in December of the year, we know they're not going to do the upgrades for a number of months, this reconditioning. They are currently out of compliance with their agreements because the equipment is not currently, in their view, in the proper condition as required by their agreement. That's their that's what the court's saying. They're saying essentially, because of that, we don't buy that the agreements force this, because if the agreements forced it, they would essentially need to go ahead and, as soon as they finish the processing cycle, do all this work, is the theory. That would bring them into compliance with their loan agreements. But they're not doing that. They're waiting till early next year, so sometime next year, to do it. They're saying, well, obviously it's not because the loan agreements require this. It's not because the loan agreements require you to do it in July. If you're right and you have to keep it in tip-top condition, as soon as the opportunity comes up, as soon as we finish the processing cycle in 2024, you would go ahead and, have to do that improvement of the equipment, right? And on contractual obligations, it's not good enough that your quality commitments means that it's highly likely the reconditioning service will be done. It's not equivalent to a certain obligation. The court pointed out that at the end of the cycle, let's be honest, if at the 100th day, suddenly, tomatoes became available and we could run the 101st day, and we still have markets for that, we could still run, the next day. We go one more day. It's not magically day 100 was the day in which the machine suddenly had to absolutely be reconditioned. That there was not really a trigger, that the end of the processing cycle was the trigger. Rather, it was something different. So the court said, essentially, tough luck. You can't do this. Now, this is a panel decision. There were 3 judges on the panel assigned to the panel, as basically as there will normally be in a decision that is sent to a court of appeal. And while 2 of the judges agreed with what I just told you, there is a dissent that holds that they should have been allowed to accrue this. The dissenting opinion holds that a $16.720 million worth of reconditioning costs is far beyond mere wear and tear. That's doing work that doesn't make sense. That's merely wear and tear. And, probably, I'll be honest, I'm kind of leaning toward, I think the lenders would be very concerned if they were not actually doing that work, that it would go downhill. The judge writing the dissent says this is catastrophic damage. It costs millions of dollars a year to repair. That's not an ordinary wear and tear. It's not the same as, your car, your car engine being driven for 2,000 miles, or let's say whatever your 5,000, 10,000 miles, your oil change intervals. It's not it's not things like that are just, work that merely takes care of ordinary wear and tear. That this is far beyond that. Okay. They also found they were fixed liabilities. They said the credit agreements and the customer agreements both essentially, from a practical standpoint, mandated that they perform these services. That was implicit in the agreements. Be honest, of course, to be completely clear here, the majority would, of course, have said it's got to be explicit. Okay, he's basically saying, as a practical matter, it's implicit. This was the only way it would work, which is an interesting discussion on that point as to how it goes. That's one of the pieces of funds that we have. Now, this does point out, though, an important thing. We do have this issue of fact of liability has been an interesting run. And in fact, as you'll find with the dissent, they'll talk about a couple of other cases where, again, it's a little iffy when the fact of a liability comes in if it's not explicit. But there have been cases, I think the 2 cases the dissent refers to involve casinos and certain things that they ended up doing and became considered to be, they had triggered the liability before the payout was there, even though there may not have been a direct legal obligation to do so. Obviously, it's best to have a direct legal obligation if you can. Be careful there. The fact of liability is tough. This does show some of the tough ways that you're going to get a more skeptical IRS, and in this case, a more skeptical tax court, and 2/3 of their Ninth Circuit panel, if you don't have direct, absolute order that you must do X. If their agreement required that, this be done. But then we get into the question, does it require it be done at the end of the cycle, beginning? I think you could say that if it was required to be done, prior to the start of a cycle, it gets iffy how you'd word it. But this is it. Now, the fact it is a 2-3 split, and considering the dollars involved, don't be really shocked if they at least try to get an en banc rehearing, of this the Ninth Circuit won't be the whole court, but it will be, I think it's approximately half of the judges get drafted to come in an en banc rehearing. You may remember about a year, 2 years ago, I can't remember how far back it goes, but we had a case where the court had ruled that, if, in an exam or when they got a notice, a partnership got a notice that IRS didn't have a record of their return, et cetera. And the taxpayer said, no, we filed a return. And they sent back in a copy of the return. And IRS said, no, we still don't think so. So they're, trying to assess changes and penalties. And an exam, the attorney for the IRS said again, we don't, never got a copy of the return. They produced another. And the question became, was that delivery of the return, did that start the statute? The original panel said yes, 2 of 3 said yes, but with a very nasty dissent that said that's crazy. You're telling me that it wouldn't have worked had they timely sent that to those places. They sent it before the due date, but it will now. That's crazy. IRS petition, Department of Justice, I should say, Treasury, did ask for an en banc rehearing. It was granted by the Ninth Circuit. Ninth Circuit reversed that. This is somewhat similar, except this time, of course, it is on the taxpayer side. So will Morningstar Packing ask for an en banc rehearing? Or would they decide to try to go to the Supreme Court? It's a little bit open. But this one might not be done. So do keep your eye on this. But as I said, in our purposes, since most of us have clients that are not going to want to pay to go all the way through to the Court of Appeals for whatever court of appeals you're looking at, and then potentially pay for an en banc rehearing, we may need to be a little more concerned about making it very, very clear why it is required for us, to do X, Y, and Z. That could include just, having things like documentation in your files, letters with the lender that essentially said, yes, absolutely. In our interpretation, the requirement to keep this equipment in good repair requires you to incur this after you've run a processing run. You're going to have to do this update. Okay, we'll get into that. Next, we're continuing on with the question of, is a limited partner under state law automatically considered a limited partner under 1402A13, exemption for most flow-through income that's not a guaranteed payment to be considered not self-employment income for that partner. And it's the case of Denon Capital Management LP et al. Versus Commissioner, Tax Court Memorandum Decision 2024-114, and this came down on December the 23rd. Now, this is a partnership that provides investment advisory and management services to affiliated private equity funds that invested in oil and gas, mining, and power. Those were the industries they were in. This partnership had 5 limited partners who functioned similarly to employees. The general partner of this partnership was an LLC, right? And that LLC is going to be the general partner in the background. So we understand the structure here. The general partner, which was a tax partnership, LLC, but tax partnership, had all management authority, but could and did actually delegate that power to the various limited partners. So the actual general partnership had no employees that it was paying to do this work. It was essentially delegating it back out to the limited partners, who then, on behalf of the general partner, were performing these management functions. My first thought at that point is that's probably getting a little too cute, but okay. I was a little concerned about that when I read it. Limited partner agreement required all limited partners to devote substantially all of his or her business time and attention to the partnership. Again, this is probably, as I said, this is one that was really pushing for the theory that if you're a limited partner under state law, this is going to insulate you. Okay. Again, that part of the agreement, was, kind of pointing the issue. It's pretty clear how this is going to turn out. You've realized pretty quickly, if in fact the courts don't agree that merely being a state limited partner by definition would exempt you from this partnership from this classification. Only one limited partners had made a contribution of assets to the partnership. Now, he made $8 million when everything got started, the founder. Everybody else had been granted profits interest. Now, the partnership did claim the other partners had bought their interest from the partner that put $8 million in, but they had no evidence submitted of that issue. So the court basically concluded there was nothing to back up that actually bought their interest. My guess is it had probably been purchased for a nominal amount, because you would think if it actually paid significant sums for that, that would have been, one of the things you would have definitely gotten into evidence. So I'm going to make an assumption here, which I think the court did, that the reason we didn't find evidence of this was because it probably wouldn't have been terribly helpful to their case. Not that they were lying, you understand, but if you paid $1.50 for your interest, that's probably not going to show you have a major amount of invested capital, because that's going to be one of the questions. Is this earnings coming from invested capital, or is this earnings arising from services performed by the partners? That's going to be the key issue if we are actually getting to the functional test or coverage. Okay. Now, these limited partnerships were actively involved in the partnership, and investors, in fact, had the right to withdraw their investments early if one or more of those partners died, became disabled, or otherwise could no longer devote all their time to the funds. That, in the view of the IRS, and probably in the view of most people, suggests those limited partners were key, right? In essence, their services were what the people that were investing were depending to be there. That's why they'd invested. They expected those people to be providing those services and their expertise as partnership and doing so full time. Now, the general partner, which was Denham Capital Management GP LLC, right, did not make any guaranteed payments or distributions to the partners in 2016 or 2017. That's so nothing came through the general partnership. Remember, in theory, the general partnership was what was performing the management services, but it appears they weren't paying anybody to do it. That could be a negative, as we'd say. Rather, limited partnership made guarantee payments directly to limited partners and a general partnership. That, there obviously is a restructuring here that you might think could work, which would be if the guaranteed payments, if payments were made to the general to Denham Capital Management, and then those were paid directly out, flowed through to the quote limited partners, but who were general partners in the general part, who were basically LLC, members, not treated as limited partners in the general partner, Denham Capital Management GP LLC. Would it have been different? I wouldn't say absolutely for sure, but it certainly would have given you an argument, I think, that's a bit better than what we have here, where it just appears like that general partner is nothing more but sitting there so we can call this limited partnership. That would seem to be the implication that we're getting here. Now, the distributions were made to each partner based on each partner's distributive share of the LP's profits, and they were substantially higher than the guarantee payments. The guarantee payments were far less than 10%, I believe actually much closer to 5% of the amount each partner received as their standard ordinary income distribution. And they only count the guaranteed payments as employment income. So this also gets us to this is a bad facts case. Bad facts in the sense that, if you're going to try to argue that they're being adequately paid with their general partners, with their guaranteed payment, and in fact, the guaranteed payments were less than they were paying many of their employees. And that's also not a good look. Okay, we're going to put it that way. Those are all bad facts. In essence, this gets back to our old pigs versus hogs problem with taxes. Pigs get fatter, hogs get slaughtered. If you become hoggish in your case, that's a bad fact. And that would make, this is not a case I would like to see go up on appeal. I'm sure Denham would, but I think it's much smarter for Denham to sit back and wait for what's currently a ruling that's coming potentially from the Fifth Circuit on a case based upon, once Soroban came down, there's a case going in the tax court that would be appealed to the Fifth Circuit, where both the IRS and the partnership agreed that really the Fifth Circuit needed to review the holding of the tax court in the other case and decide if in this case they're going to argue the case. Let's argue before the Fifth Circuit, because that's what we're going to end up doing anyway. What the tax court's going to do, what's happening here. Let's go ahead and cover this, because it's obviously the key issue, and we can certainly get a lot more efficient. And it makes you wish the BOI was going in a record like that with litigants that were kind of thinking along that path, but that's not how we're going there. In any event, we do have that. So keep an eye on that case. I would suggest Denham certainly may file for an appeal, but I think they'd really love to get the Fifth Circuit in on this ahead of time and get that ruling out of hand. So we've got at least something else in there, okay? So the court, citing the tax court's prior decision, published decision in Soroban Capital Partners versus Commissioner 161 TC 310, found it had a jurisdiction to decide if a state law limited partner qualified for the exclusion. Again, one of the key questions is, and Soroban's point, and this one I think absolutely would be in this case, was that if you're a state law limited partner, you by definition would get that 1402A13 exclusion, except for any payments made to you that were guaranteed payments for services actually performed. The court says, nope, we're not saying state law limited partnership status is sufficient to answer the question. And we're doing this based on the precedent set in the tax court case of Soroban Capital Partners. Okay. The court again looked at the phrase limited partner as such. We're back to that argument we had with Soroban. The court says if they really meant a state law limited partnership, they would have just said limited partner. Limited partner standing by itself would probably have been most rationally decided to be a limited partner as defined under state law, because there are state law definitions of that, have been for years. However, the court said Congress didn't leave it at limited partner. They said limited partner as such. They said that means under basically the canon of statutory interpretation that's referred to as the lack of surplusage canon. I love the terms they give there. In essence, every word has to have a meaning. There shouldn't be any phrase. If your analysis renders any phrase in the statute, the relevant part of the statute looking at, as being irrelevant, we could take it out and the meaning would not change one bit, then your analysis is probably wrong. And that's the court's decision here. They're saying they didn't just say a limited partner, they said limited partner as such. Therefore, as such has to be interpreted. And they then go back and say those words must have a meaning. And they go back to the Rankmeyer case from 2011. Remember, Rankmeyer was dealing with not a state law limited partnership, as you'll note, Rankmeyer, Campbell, and Weaver, LLP, but was a limited liability partnership, which again, as you know, is a different beast. It's not a limited partnership under state law. It is rather this odd beast, this wrapper that goes around a general partnership agreement that converts it into something a little different, right? Which gives some liability protection. The court applied a functional test to the partners there to see what's there. So in this case, they're going to apply a functional test to limited partners in this limited partnership in Denham Capital Management, LP, to see what are the functions they're doing. Now, the functional test, we're going to look at, is this a passive investor who's not really doing anything, or is this an active participant? Passive investor goes back to a case like Hardy that we discussed many years ago, where Dr. Hardy was found to have simply put money into this Surgeon Center partnership. But even though he did surgeries there, he did them as a customer, right? He wasn't really involved actively in running this thing on a daily basis. He was not deeply involved. The problem here is these 5 limited partners were deeply involved. In fact, as we noted, the investors could pull out early if any of them ended up not being daily there running the company, running the partnership. They could pull out. That suggests they're much more of an active participant than a mere passive investor. The other investors were, investors could be a passive investor, but these guys were different. And then where'd the income come from? Did this income arrive from active management of investments, the services performed, or from passive returns on capital? The court obviously decided that in this case, it came from actively managing the investments. That was what they were paid for. That was clearly what the agreement suggested they were there for, was, for this particular issue, because again, they didn't invest much capital. So they weren't just passive investors running their, they were very much actively involved in running it. What was their role in generating the income? Again, the court finds that their role in generating the income was not sitting back and waiting for money to flow in. Like, if you had a bunch of U.S. Treasury bonds, you'd be sitting waiting for the checks from Treasury to come in. No, they were out there generating, causing things to happen that caused these funds to make money, which means they were involved daily in getting things run. That was their key issue. Capital contributions versus distributive shares. This one, the court says, if in fact, the distributions are far out of line with the capital contributed. In fact, in this case, even the partner that put in $8 million was getting way more than $8 million out every year. That doesn't look like a return on investment. Rather, and the others had put nothing in. That looks like you're being paid for services. That was the purpose of doing this, okay? And are you involved in management and decision-making for the partnership? And again, in this case, they were doing it, right? The fact it went to the general partnership, who then just simply said, oh, okay, you guys take care of this. Not terribly surprised the court was not impressed with that arrangement, right? It would be there. And how much time? Let's see, I look at my own investments, and realistically, my investments, I'm not like under an obligation to spend so much time working with them. I'm basically, sitting there. I'm going to check like my, my retirement accounts, check my investment accounts, and make sure they appear to be doing fine. They're not doing as well today as they were, before Friday started. We all know Friday wasn't fun in the past week. But yeah, we know things like that. But I'm not there daily, fine tuning and being involved. And I'm certainly not involved in running the companies that that I'm invested in. I have a feeling Microsoft is not going to let me come in because of, the amount of shares I indirectly hold via mutual funds or ETFs, in Microsoft. Not really going to let me go down there and run the company. Neither will Apple or Google. I'm pretty sure none of that's going to happen. So again, those time commitments, these guys again were by their very agreement with the partnership required to devote full time, full business time. When they're involved in a business, they're supposed to be doing this. That's also a key issue. So this case, the court found that functional analysis clearly found these partners did not qualify for the exclusion despite being state law limited partners. Again, the real fight here is whether state law limited partners, by definition, automatically means that you qualify for 1402A13. Right? That's really the fight. I think generally once you get to functional analysis for structures like this, you're toast. If functional analysis is what is required, definitely in this case, you're toast. It's over. So the question is going to be, does the language of 1402A13 really say if you're a state law limited partner, you automatically meet those requirements? And that's going to be one of those issues. And again, we're getting into that interesting discussion about, the Kansas statutory interpretation, which became a big issue with Loper Bright case that came down. That's in analyzing a reg, but still the same concept is there because that's how the court's supposed to analyze if a reg interpreting this is proper. Does the reg deal with as such? And the question would be if it doesn't deal with as such, then it might not be a valid reg, or it probably wouldn't be a valid reg, the theory is, because it should give us an answer to what does that mean. That doesn't mean that this is the answer, but it definitely is the answer the tax court has come up with. So we know that. We want to kind of stay away from that functional test. So we're off on that. Okay, let's go on to the roller coaster. This is where we stand with the beneficial ownership information reporting. Now, let's back up a week. At the end of last week, right? So basically, they're sitting there the end of the prior week. So we're back here on December the 23rd, the broadcast I did last week. At that point in time, we had the requirement to file beneficial ownership information reports was on hold. The U.S. District Court, for the Eastern District of Texas had applied a nationwide bar on enforcement of the CTA and basically, held back the deadlines that were in the final rule and said that none of that was to be done until, the case was actually tried. And, they did because the court in Texas had decided that the plaintiffs in that case were likely to win. Now we go likely to prevail. And that was both on the question of whether or not Congress had the power to do this at all under the Constitution, or even if they did, even if they generally would have the power under the Commerce Clause, did at least two of the first 10 amendments, two of the Bill of Rights amendments, end up, basically barring Congress from doing this based on the fact that it would have violated either their First or Fourth Amendment rights. First Amendment for freedom of speech, free association is generally going to be the issue argued here. And then secondly, Fourth Amendment is unreasonable search and seizure. The government is forcing you to supply information, right? In essence, that's an unreasonable search and seizure on the Fourth Amendment was their argument. Again, that's where we stood a week ago. But at the time we knew that basically the Department of Justice had filed an emergency request with the Fifth Circuit to have the case, to have that injunction, rehearing on that, and to stay that injunction, right, pending the final decision in the case. Okay, that was it. Okay. So now this week what we had an order issued on the 23rd. So now we get to Monday the 23rd. During the day, we end up with a order issued in the Texas Cop Shop Inc. versus Garland. Case number 2440792. This is document number 140 basically issued on December 23rd, 2024. And that document was considering the request for the emergency stay of the injunction issued by that district court. The three-judge panel analyzed four factors that should be analyzed, which is basically the same four that the district court analyzed. But they found that, in fact, they were in favor of staying the injunction. So now we're not looking at whether you apply those four factors to, the plaintiff's request for a stay of the law. Now we're looking at whether you apply, now we're going to apply those four factors to the district court's application of the injunction and whether we should stay that. So three of the judges analyzed the four factors. All were in favor of staying the injunction on a nationwide level. One of the judges, as we'll discover, was in favor of staying basically getting rid of the nationwide injunction, but keeping an injunction as it related to the plaintiffs in the case. The panel discovered, this is in the very short notice we got that ruled on this, they found the government was found likely to succeed on the merits in this case. That is blatantly 180 degrees different from what the district court found. They found the government would be irreparably harmed by a delay in enforcing a validly passed law. Again, 180 degrees different than what the district court found. A stay would both substantially injure other parties interested in the proceeding and not be in the public interest. In this case, what the court's pointing out is, since it was meant to stop money laundering, stop criminals from hiding behind, various LLCs and using that as a way to make it very, very difficult to find the parties responsible for whatever's going on, because by hiding the ownership deep and burying it, they said, inability of law enforcement to be able to access that information, plus the fact it put the U.S. out of compliance with certain international treaties, was a substantial injury, right? Those crimes could go on basically now and be much more difficult to detect, and that would happen all the time this was stayed. So because of that, they found it was not in the public interest to have this stay there. They found that the parties would not incur great expenses to comply with this. And essentially, they just kind of said, skip it. We're fine. We're not going to worry about this. We're going to essentially go on. Now, I will say that the plaintiffs in this case, so now back to the original plaintiffs who are now going to file an appeal of this one, we'll keep following along. We're going along with this. They tried to file for an en banc rehearing. What we're going to discover is that they argued, which I think is correct based on the reading here, was that this particular ruling made very short shrift of what the district court had done with regard to the complaints on the First or Fourth Amendment. Effectively said they hadn't really dealt with them. Now, obviously, the plaintiff said, no, the district court had dealt with them, right? And because all they said was hadn't been dealt with, so we're not going to worry about those. I do think that is not correct. Having read the documents, I'm more in line with saying that, yeah, really, that this order should have dealt with the First and Fourth Amendment theories there. But nevertheless, they really did that in very short shrift, so we're there. They got rid of it. As noted, one judge, while agreeing that the nationwide injunction was not justified, still believed it should have continued to apply to plaintiffs in the case. Now, this is a separate issue we need to be aware of is also at play here. There has been great concern expressed by Chief Justice Roberts regarding district courts issuing blanket nationwide injunctions against enforcement of a law. Having basically about 600 U.S. district court judges out there, or at least if we filled all positions, we would. In essence, a lot of chaos can be done because you can probably find at least one judge somewhere that you can get to agree that whatever law you don't like is unconstitutional in some way, shape, or form. Because of that, if you can basically forum shop properly, which plaintiffs are known to do, you probably can get it done. And that creates chaos. And by the way, it's chaos not just with a law like this, it's pretty much any law. Certainly you can expect, especially in the hyper-partisan times, that we are going to see challenges raised when we have a change of administration, certain changes of policy, and maybe certain laws passed by Congress, signed by the new president, that we're going to have people challenging those laws and attempting to get them ruled unconstitutional. And as you could see, we could have another set of injunctions, right? We just need to find one judge who will issue an injunction. And yes, it'll be appealed. And yes, quite often those will be knocked down. But there is concern that that's happening way too often. And there has been a move afoot to try to make it much, much more difficult to get these national injunctions and make it. And there's more skepticism at the Circuit Court of Appeals level and Supreme Court level about, whether or not these wide-ranging injunctions make sense. So third, I think what we have here is the final judge says her main concern was, really this one guy sitting in Texas, shouldn't really be able to make rulings that ignore the whole fact that two other district court judges have both ruled just the opposite, the same way this panel did. That somehow, it's kind of an unbalanced situation when you just need to find one to give you an injunction, right? Even if 599 other district court judges all agree that everything's fine, this law is perfectly valid, that one gets to essentially, be king for a day, at least until it gets overturned. So we're there. Now, that ruling, when it was issued, so Monday, December 23rd, we were back to the due date for most initial reports moved to January 1st, 2025, if a business was in existence on January 1st, 2024, right? We're back to that, and we're back to the 90-day rules and the 30-day and the upcoming 30-day rules. That's where we're sitting. The 90-day rules for entities formed in 2024, and the 30-day rules for entities that will be formed beginning, after Tuesday of this week. Once we get to January 1st, 25, we'd be under a 30-day rule. That's where we ended up. Now, we're not going to stay there. We actually moved twice again, but this is where we were on Monday. So keep this up, okay? As the week went on, as I note, things continue to change. What happened first was on the evening of December 23rd, late after the stay was issued, this is like late at night or at night, they provided for extension of times to file the reports to take into account the confusion caused by the district court stay, right? So what this said was, and you may have heard about this one, so let's take those January 1st, 2024 existing companies. We moved their deadline to January 13th of 2025, right? That original deadline would have been January 1st, so we're going to give them 12 more days to file. So that means we're not worried about people who are unavailable now, on vacation, away, that you would have to scramble to get things filed. We're going to let them get back to the office and get things filed by January 13th. That may still not be a lot of time in a complex situation if nobody's done anything, but the theory being we're giving you, in essence, 12 days because it took 12 days for the stay to be lifted. So that's why they're giving you 12 days. You're going to have the same number of days you had before, right? Now, companies created registered in the United States on or after December 4th, 2024 that had a filing deadline between December 3rd and December 23rd have until January 13th to file their initial reports. Right? That would be there, okay? Companies created registered in the United States between December 3rd, 2024 and December 23rd have additional 21 days from the original filing deadline to file their initial reports. We give them 21 days. Our disaster relief rules still apply, and they also remind us that our companies created and registered at January 2025 are going to have 30 days. That'll just be automatic. And finally, the plaintiffs in the case back in March, National Small Business United versus Yellen, they will still be exempt from reporting, right? This didn't change anything for those people. They were exempt coming in. They were exempt on December 1st. They were exempt when this order came down in December 3rd. They were exempt on December the 23rd, right? We're exempt all the way through. They haven't changed. So that case, until the 11th Circuit rules about something, those guys have no change in condition. Okay. Now, as we'll discover, this also would not be the final word because that would have made too much sense. So again, Monday of last week, by the time all the dust settled by midnight that night, we were thinking, okay, January 13th is our deadline. And of course, people got notices out. What I found amusing was, because I got a little copies of these notices from various sources, It's amazing how many of those notices came out on the morning of December 27th or during the day, December 27th, right? At some point, the 27th, these notices came out. It was kind of funny as I watched number 26 come out. Now, here it is, late in the evening. So we have these December 26 notices. Everybody got back, 23rd it was there. They weren't there on Christmas Eve, weren't there on Christmas. Put all these notices out then. They got all these mailers out to their clients or their customers, if they were a tax reporting service, saying that, hey, the deadline now is June 13th. They've struck down the stay at the district court. In the evening of December the 26th, and I think it was probably right around 8 p.m. Eastern, as far as I could tell, that this actually got posted. Basically, the Fifth Circuit issued this order. Okay? The Fifth Circuit stay of the injunction had been issued by a motions panel of the Fifth Circuit. Gang, we're setting up the Fifth Circuit to essentially reverse the Fifth Circuit. Okay. I mean, that's why I have to explain this. The motions panel of the Fifth Circuit had heard the request for the stay. They issued the emergency stay. At that point, they then transferred the case to what's called a merits panel that would hear the expedited appeal. Right? So again, we're still going to get the appeal. We're still going to hear whether that injunction was correctly done. And in theory, if after we have the full arguments, the panel then decides that, hey, you know what? We're okay. We're okay with this. Yep. They would put the injunction back in and bar future requirements to have to update or file reports. File the initial reports or any changes. At that point, they would restore basically the injunction. At that point, however, now the merits panel issued a new order, and they vacated the stay issued by the motions panel. They're going to accept everything else the motions panel did, because if you don't accept what the motions panel did by transferring to the merits panel, then you kind of just took yourself out of the mix. But okay, so we're going to keep that part. But we are still going to go back and say they're going to vacate the stay issued by the motions panel against the district court, injunction. So essentially, the district court injunction is back on. They said they did so to preserve the constitutional status quo while the merits panel considers the parties' weighty substantive arguments. That suggests the motions panel does not agree that this is a slam dunk for the government in the way that the stay panel did. Or I should say, or the motions panel, or I should say the merits panel doesn't believe it's a slam dunk. The motions panel thinks it is. Which means we know there's disagreement now within everybody. Now, that's kind of the interesting aside. They don't tell us why they're doing this. There's a lot you can speculate on, one of which is, reading between the lines of weighty constitutional substantive arguments suggests that, they think that maybe there is, that the constitutional arguments are, maybe more substantial in place, that this would be better to leave that there. Maybe they're concerned with the First and Fourth Amendment because they did pick up on the theory that they hadn't really dealt with those two, and those could be their weighty substantive arguments. And we don't know what else is there. There's also the theory, of course, are they going to mainly look at whether a national injunction should have been issued? That would be the simplest way to clear this off without actually ruling on the matter yet. Just kind of say, well, it shouldn't have been a national injunction. The injunction could still cover the plaintiffs in this case. And with that done, we're done with dealing with whether the injunction's proper. We got that done. It's all we're asked to do. So, yeah, we have no idea what they're thinking, right? All we know is this is here. So we don't have any additional reasoning backing up this. We just know it's going to happen, right? So, like I said, various factors probably played into this. We've got it. So, bottom line, at this point, enforcement of the CTA is on hold. Voluntary filing is still allowed by FinCEN. So, we're back to we are on hold. Now, the question becomes, obviously a big one is, how long are we on hold for? Well, at the rate this is going, 2 days. I mean, but maybe we got something a little bit better. FinCEN did on December the 31st post, or I should say website, It'll be there. I should say alert December 27th. I got 31st up there, but December 27th, they posted their alert. They said, in light of a recent federal court order, reporting companies are not currently required to file beneficial ownership information with FinCEN and are not subject to liability if they fail to do so while the order remains in force. Same language we had before, right? However, reporting companies may continue to voluntarily submit beneficial ownership information reports, right? And as they note at the very end of their description, which goes on and talks about a lot more of the history, it says, as of December 26, 2024, right? The injunction issued by the district court in Texas Top Cop Shop Inc. versus Garland is in effect, and reporting companies are not currently required to file beneficial ownership information with FinCEN. So, what that means is, we're back to where we were essentially at 8 a.m. on the 23rd of December. We're back to, we have this order. This order is being questioned by the Fifth Circuit, is being questioned before the Fifth Circuit. But as long as this order remains in force, there will be no penalties for not filing the report. And there's not a deadline. Dates don't matter. However, they're still using the language they did a week ago, which I had the concerns with a week ago, that, while the order remains in force is the problem, right? If in fact this order is overturned, whether it's overturned on the merits of the order itself as a whole, meaning that the panel believes it's more likely it is constitutional, or whether it's overturned simply on the fact that the court overstepped its bounds by issuing a nationwide injunction, when this clearly is going to eventually be decided by the U.S. Supreme Court, whichever way you're looking at that, suddenly you might be sitting on a deadline very, very quickly. Now, as we know, the last time this happened, FinCEN went ahead and, opened up and allowed the stay to go on, right, for a longer time. We got the extra days. You would hope they do that again this time. I think we'll at least get to the 13th. And I think we're probably going to get beyond that. We'll talk about it here in just a second with the next issue I've got. A report that was in a Forbes website article. We'll talk about what some of the likely deadlines are here, unless another court steps in. So this takes us to an article by Kelly Phillips Erb, attorney from Philadelphia. She's a columnist for Forbes on their website related to tax matters. In an article entitled "In Whiplash Maneuver, Court Rules Beneficial Ownership Information BOI Reporting Requirements Are on Hold," that was posted on December 27th. Later in the day, she noted that there are some key dates we need to know. We know right now by following what's been posted, what was posted after that order on the basically involved with the, in orders and items or documents related to this case that are available via the Fifth Circuit, via PACER, and in some cases just via the Fifth Circuit's website. First thing we know that December 31st, 2024 is the deadline for the government to file a response to the plaintiff's request for an en banc rehearing on the original motion. Now, it appears after Kelly wrote this article, another document appeared on the Fifth Circuit website. It appears there is now an unopposed motion filed by the plaintiffs to withdraw the request for the en banc rehearing. That's not surprising, but it does mean that this whole issue for an en banc rehearing on the original motion has been withdrawn. The government did not object to that, it would appear. So assuming that is correct, that there's not objections to that being filed by the government, that no, we're not going to go forward with an en banc rehearing. That would have been one way to address this. December 31st, we've had the question, will the whole court take this matter up about whether the injunction should have been issued? And they're saying, okay, no. Right? We're going to say no. It looks like that's been mooted. Don't know if that's been mooted because the government simply just decides, hey, at this point, let's just give up and let's just try to get something that makes sense instead of rushing to try to get something together before the original deadline. Or if this just means that they're going to say, forget about the Fifth Circuit. We're tired of getting these on again, off again things. So, will they apply to the Supreme Court to step into this case, right, on this issue and go for an emergency filing there? That's an obvious possibility in all of this mess. So, yeah, we're just got to see how it goes. There is a February 2024 is when briefs are due for the expedited hearing. Now, there are various deadlines in February imposed on both parties, with the very final deadline imposed on, I believe it's imposed on the plaintiffs for their rebuttal to the government's response. is on February the 28th. So this is all through February. This is here. No documents are due before February. They're all due during February. So bottom line, that write-off tells you that we are not, if the answer is going to come from this expedited hearing, we're not getting an answer until after the oral arguments on March the 25th. So March the 25th would be when the oral arguments are given. Now, this is an expedited rehearing, so we'd expect them to move faster on the decision here than they would in a traditional hearing. Because remember, September 27th of 2024, which now is over 3 months ago, was the date that we had the oral arguments in the 11th Circuit on the original Alabama case. We still don't have an opinion there. I would not expect this to take 3 months to get this opinion out. You know, it's an expedited hearing. There's little point expediting a hearing and then just sitting on the answer forever. But I would expect that it takes some, we'll see what comes up. That does suggest, though, assuming they issue their opinion shortly after the hearing, that kind of suggests that you might see the answer come up just before the end of tax season. That is a potential real problem for a lot of CPAs. Any CPAs who are assisting clients in filing these forms, you probably want to have a talk with your clients before tax season and indicate that while you will may not be able, especially if, let's say, you got 100 clients, all of whom need to file, and like all good people, they of course were procrastinating to the last second to file, and now they want to procrastinate some more. If they're all going to wait and not have their documents ready to file and can't file them on their own, the question you've got to consider is, can you take all 100 on an absolute drop dead deadline that could occur at the worst possible moment during the filing season? Right? You've got all these extensions to get out. You got behind, so you're actually on April the 15th that morning. April, so you're getting the 14th. You end up like, oh man, we'll just get all these done tomorrow, and we'll get all these done. And then you wake up and you discover that late in the evening, because that's when these things always seem to get posted, the Fifth Circuit had ruled, and they said, yep, the injunction is back lifted, and therefore now April 15th of 2025 becomes the date all of those reports are due, and now all 100 clients are calling you trying to get the reports filed that day. I think I have to tell clients, look, at this point, and I think, to be honest, also with this rapid fire change of position, I got to tell clients, look, I can assist you to file the reports right now. If you want to do that and just not worry about whether or not this is it, that's fine. You do have the perfect right at this point to not file, but understand that I absolutely cannot guarantee you that I'll be able to help you, depending upon the timing of a required filing, if in fact it's ultimately found that these things are valid and need to be filed. So if you want to go with that, and I also I'm going to have time to inform you that it got overturned. So that's your issue right now. If you want me to help you with it, I can do it right now. If you don't want my help, then fine. If you want my help, but you want to wait, well, you can't have everything you want. To basically, you can't always get what you want, to quote the Rolling Stones. You're going to have to figure out what compromise you want to make. Are you taking personal responsibility to get these filed? Or are you going to do this? One potential compromise solution is the client still got to be able to get it filed on the website themselves. I don't have time to do that, I'd tell them. Potentially, I can't guarantee I have time to help you with that. Would be that, I can assist you right now in getting the data on the forms. I can assist you right now with getting that PDF ready to go. And then you're responsible after that, if any of the information changes on the form, to let me know. We could update that. Or you may need to update it, depending upon how quickly your change goes through and how quickly, we have a actual, deadline release comes in. But we could do that, so you just be ready. You'd have the document. And as soon as it says go to file, you could go online and file the form. We can file it right now. Most attorneys I'm aware of are suggesting filing right now. This has become crazy. As one response said when I posted online, said in response to a post I had saying this is here, just simple response was, this is nuts. Which, yeah, I mean, the on again, off again, on again, off again nature of this is making it very, very difficult at this point in time. And I think you got to communicate to clients saying, look, I'm not responsible for the fact that the courts keep turning this on and off, right? And I can't guarantee you they won't turn it on at a time when I'm not going to be able to help you. You know, because even if it wasn't tax season, you're essentially committing to being available on 24 hours notice for all the clients that haven't filed. And I don't think that's a reasonable commitment for anybody to take on. And I know most attorneys aren't taking that commitment on. You know, they're saying there's a possibility those will happen. I can't guarantee it won't. And if it does, and especially because, you know, we have a change administration, and the incoming administration is not, as of the instant I'm aware right now, hasn't really made any statement on how they feel about this. And it's possible that whoever's in charge of the Justice Department may very well feel like, nope, go with this. We need this tool. We're going to enforce it. In fact, we're not going to give you any extra 21 days. You guys knew about this all along. You know, as soon as it comes due, we want your report in there. If you don't get the report in there, we're going to penalize everybody. I don't think that's going to be the answer, but I absolutely cannot guarantee anybody it won't be the answer. I think that's the biggest negative. So again, your likely answer is the end of tax season. That's going to be our key problem here, that we have an answer at the end of tax season. This has been the current federal tax developments for the week ended December the 20th, or basically the week beginning, I should say, December the 30th, 2024. Current federal tax developments are brought to you by Kaplan Financial Education and your state society of CPAs. Again, I'm Ed Zollers. I am updating this from here in Phoenix. If you have any questions, you can email me, edzollers@currentfederaltaxdevelopments.com. I also participate in state society websites for certain societies. So I'm on the Connect sites for Arizona, New Jersey, Idaho, Minnesota, Illinois, Washington to some extent. And I also, you know, like I said, I'm available here on the website. I am doing a little more work these days. We are beginning to, and I'm beginning to make use of, if anybody hasn't already done it or has access to it, you may, at least on the simplified version, this thing called Notebook LM, which is a very, very useful tool from Google for summarizing documents. It's very, very limited, not large language model, but a language model that simply goes after, you know, the specific documents given to it. I'm able to use that to get summaries together much faster now. So I'm hoping to get a lot more posts to the website when things come up. So keep an eye on that. I will note when Notebook LM has been involved. So far, it's been very, very reliable. I haven't caught it except in one case where it just got a little confused over what was Denim, because Denim's two companies' names are virtually the same. And it got a little confused about, you know, plaintiff, and other parties. And the tax court confusingly referred to plaintiff only referring to the general partner, or I should say the limited partner, but then used the term, you know, so the problem was that it wasn't clear because, yeah, it was a mess because there were two Denims that were actually plaintiffs. And one was the general, one was the limited. And they were talking about the fact that no guaranteed payments were paid to the general, were paid to the plaintiff. And it was like, we're paid to Denim. It's like, what? Yeah, a little messy there, but otherwise working pretty well. So again, otherwise, we'll take a look, see what's coming up this week over the New Year's, you know, what happens. We'll see if we get any other new developments for the BOI, because every time I've thought this thing's been done and we now have the final answer, we haven't had the answer. So we'll see what goes on. And by the way, Congress comes back in shortly. So they may actually put back on the table just extending the deadline to January 1st of 2026, which be kind of nice if that actually passed this time, but we'll see what they get through in any event. But otherwise, it's been the current federal tax developments. We'll see you next week with more discussions of what's gone on in the area of federal taxes.